Hi, I'm Burney from NextPoint, and we are talking with Tom O'Connor, the author of the book eDiscovery for the Rest of Us, which has recently been republished in partnership with NextPoint. Tom, you go through so much in this book, and it's so incredibly helpful, but I would like to just ask, what should lawyers specifically be discussing about eDiscovery with their clients? And when should they start? Like, should they be talking about this with the clients right from the beginning, or should they wait a little bit? What are just some of the helpful tips and takeaways that you could share with us today?
Don't wait. Much like voting in Chicago, do it early, do it often. Um, um, it's no, you don't want to wait. In fact,
Yeah,
not only do you not want to wait, you really don't want to wait for litigation. You want to be
yeah,
having some of these discussions with your clients as part of your ongoing relationship with them. So really what you want to talk about is what is their preservation obligation. But to do
yeah,
that, they need to know what they have. So one of the biggest problems I have in engagements is I'll ask for a data map. And I've been involved in
right.
cases where I asked for a data map from day one. And 3 years later, when the case finally went to trial and we won, I still didn't have a data map. You need to get them out, especially in a distributed environment, a company that has offices all around the country, if not the globe.
Right.
Um,
Right.
each of those is often treated as a fiefdom by the internal IT departments, and they run things maybe the way they want to run things. You need to know. So you need to know what you have before you can talk to them about their preservation obligation, which
Right.
is if it's going to be something that is even remotely relevant, you better preserve it. Now, the last thing there, I think, is to point out preservation does not mean production. A lot of
Yeah.
clients get really antsy and think, oh, this is going to cost a fortune. We're going to have to review all this. No, you know, you want to say to the court, we preserved everything that looked like it might be beneficial or relevant or even potentially relevant.
Potentially. Right.
Yes, but now we're going to produce X, Y, and Z because we've looked at the data and this is what we pared it down to the things that are in fact important and may in fact be used at trial. Um, and,
Yeah.
and, and so I think you want to be having those conversations way ahead of time. It's really the interplay between e-discovery and info governance. You want to be talking to your clients about what they have and how to preserve it. And it doesn't have to be Boeing. It doesn't
Yeah.
have to be
Yeah.
General Motors. It can be Robichaux's bait and tackle shop out in Thibodaux, Louisiana. But I guarantee you, Robichaux's got e-discovery concerns. I worked on a
Right.
case over 10 years ago where the government, this is for the federal defenders, the government was bringing criminal charges against the Hells Angels. 6 defendants, 22 computers. So I tell my clients, if the Hells Angels had 22 computers that were seized by the government, your client has something. And here's the thing to ask your client when they say, oh, I don't have any of that stuff. Do you have a cell phone?
Yeah.
You have a
Right.
cell phone, you got electronic data that may be relevant. As
Right.
Chief Justice Roberts said in the Riley case a number of years ago now, when they talked about you need to have a search warrant to look
Right.
at somebody's cell phone when you arrest him. Chief Justice Roberts said all the vagaries of our life are contained on our cell phones. Um, that's you should be saying that sentence to your clients, and it's not just personal;
Right.
it's business. You need
Right.
to be able to know where that is, how to preserve it, and then what to do with it if you need to.
And I would just quickly add, Tom, because I know you're going here. That just really streamlines
Ah,
everything, down the river, right?
yep.
From an aspect of cost, from an aspect of practicalities, from talking with the opposing side on production aspects, just having all that knowledge, which I think is so good that you point out both now and in the book. And even in the book, we have some checklists about this. Like, here are
Yes.
some bullet points on things to make sure some of these questions asked with clients. And
Yes.
that's just so helpful, Tom. Thanks for sharing. We really appreciate that. And
That's
thanks
right.
all of you for joining us today. Be sure to be on the lookout for your opportunity to get a copy of Tom's book, eDiscovery for the Rest of Us. Thanks for joining us, Tom.